All right, good morning, everyone. Today is Thursday, May 26th, and this is a meeting of the Policy Committee. We're happy to have you all here. The agenda is in the chat and also available on board docs. We're going to begin with some 200-level policies that Dr. Lutz has reviewed with our building principals. And so I'm happy to bring up board docs if that will be helpful to you. I think that was helpful at our last meeting. Give me just a moment to share my screen and we'll go from there. And Dr. Lutz, why don't you just talk about the process you went through in reviewing these policies?
Sure. So to review the policies, we looked over what was recommended from PSBA and then also from our legal team. And then we took those policies back and compared it to what was in our student handbook and our student code of conduct. So in particular, our student discipline, you'll see that there's some additional verbiage on that one because we wanted to make sure that our code of conduct aligned to the student discipline policy so that we could refer back and forth to those if we had student discipline issues. There's just a few changes in there. You'll notice, particularly in on and off campus activities, there's some additional verbiage in there. And that was recommended by PSBA based on some recent case law that has come out to discuss when students can be held accountable for their actions, when they're off property, and then also when they are on property for us. And so that has been updated. Our code of conduct is does not require any changes simply because everything in our code of conduct has already linked back to these policies. But I've been through those with the principals so that they're aware. And we've actually gone through and audited the entire handbook so that we made sure we cleaned up some of the language throughout there. Okay. Any questions on the specifically the student discipline policy?
I do want to mention to board members that our student codes of conduct go to print as part of the student handbook in hard copy in June each year, so that they're back to us and ready to be distributed to students in early September. However, if we do make any adjustments through the discussions over the month of June, we can amend those codes of conduct as needed on our electronic copies, which are provided on our website. And so we have consulted with our solicitor to make sure that any updates to the code of conduct, as long as they are provided on our website, that we're solid, even after the handbook has been published in hard copy.
Policy 220, which is the student expression, distribution, and posting of materials. The main change to that one is that there is now a procedural form that goes with it so that students who wish to distribute any type of materials to other students need to fill out that form, get principal approval prior to them being able to distribute anything. Just to be clear, that wouldn't prohibit like the local Little League from coming in and giving flyers. This is strictly for students who want to disseminate information. Okay.
And I'll just share that. So that form is linked so that you can see it.
Okay. And the principals are aware of that form so that they have it to give to any students who might wish to disseminate materials so that they can get approval for that. Under policy 222, we're just updating some of the language around vaping, e-cigarettes, and medical marijuana products on school grounds. Obviously, those are kind of newer products that weren't previously contained within our policies. Just to draw your attention, even if a student did have a prescription for some type of medical marijuana, our school nurses would not be distributing that. We also updated policy 227 for controlled substances and paraphernalia. There's just some minor changes to this policy, including consistency with the student discipline policy. So that links back to that policy 218, and then also information on lookalike drugs has been added in there. So if students bring something in that may not actually test positive as a drug, but if they are representing it as a controlled substance, it gives the same weight to this policy as if it were an actual drug.
I want to make sure on the lookalike drugs that the board is, fully aware. So an example of this would be, let's say a student were attempting to sell a bag of spices as if it were marijuana. So if that occurs, that's a lookalike drug. So if it is designed to deceive others as a drug, then the penalties are the same as if it were actually marijuana in that instance. And I just want to pause for a second because I know a few of these policies, the tobacco and vaping, I'm sure you noticed there's a lot of bolded language. So the legal updates have been substantive in a few of these policies. It's why you're seeing them now, rather than earlier this spring when we were in the 200s. We wanted to take some time with some of these more substantive changes and make sure that our student handbook was aligned and that our solicitor had reviewed these policies in addition to PSBA, just to make sure that we were fully briefed before we brought them forward to the board for review.
Policy 237, which is electronic devices, has also been updated. Those are just a few descriptive changes. You'll notice that section 504 service agreements are highlighted. That's to allow for, one particular example would be students with diabetes often now have monitoring systems that run through their phones. And so those phones would then be allowed to be connected to our network so that they have continuous Wi-Fi and the student is medically safe to monitor their glucose levels. So that has been added. And then also you'll see the bolded language that every once in a while, teachers do ask students to use cell phones in their classes under their supervision. Obviously, we're a one-to-one district, so those cases are few and far between. And from speaking with the principals, they generally have to get principal approval as well, because the principals want to know if they're walking into a classroom why students would have cell phones out. And so, but that has been updated under this policy. You'll also notice just a couple of changes: play or edit audio or video data up at the top, and to access online applications. And then last is the school wellness policy. So the school wellness policy informs not only student services, but also some of our food distribution. And so that's something that we'll be working closely with the business office. But this will be important for, we sometimes as a district get audited for our school wellness policy. So all these changes are consistent with what PSBA recommends. And then also one of the things that you'll see in there is it requires us to establish a student wellness committee. So I'll be taking that on so that next year we will put out a call to any interested parties to participate in a student wellness committee. And just some things that we would look to do is, offer healthy food choices to students, encourage students to try new fruits and vegetables. I've I've in the past run, like a coat drive through the student wellness committee, just things to make sure that students have what they need to be safe and active learners within the school community. And that is all. If there's any questions on any of the 200 policies.
Can I ask a question that's not directly related to policy, but that is directly related to the wellness committee?
Mm-hmm.
I guess is there that seems like, again, it's sort of a broader take, but it seems like a really good, particularly with respect to the school community involvement and some of the, like the co-drive you mentioned, some of the broader things. It seems like a really good way to overlap with some of the other things, I guess, that some of the students are doing, like community affairs or oh gosh, I forget the name of it right now, but I know that the high school students can do for community service credit and things like that. Is there, can those things be overlapped, or do they have to be kept separate for policy purposes? I'm just curious.
No, absolutely. We can overlap with any of those activities. One of the goals of the Student Wellness Committee will be to get students to serve on the committee so that they can define what they'd like to see as healthy choices for themselves. So absolutely, we would look to overlap with already established committees. We just have to have a standalone with an agenda, with sign-in sheets for auditing purposes.
Sure, of course. Thank you.
Yep.
So in the 200s, the plan would be to bring forward the remaining 200 level policies, with the exception of one, and that's 236.1. So we haven't taken a look at that one yet. We want to take a little time with that over the summer, and we'll bring that to you in the fall. That's a brand new policy on threat assessment. And while we are engaged in threat assessment training, and we have a threat assessment team at the district level, we want to be very careful that we are in compliance with this policy as we start the new school year. So we're going to take a little bit of time this summer to review that. So the remaining policies that would go on the board agenda for the 7th are 218, 220, 222, 227, 237, and 246. We have 6 policies that Dr. Lutz has reviewed with you that we would bring to first reading. And by way of summary for whoever among you, whether it's Ms. Green, who's going to be providing the report, I think, in general, these are policies that are reflected in our student handbook, in our code of conduct. I think the important things for the public to know is that we've been very careful to make sure that we've aligned school board association guidance, solicitor guidance, and our student handbooks and codes of conduct, so that they are all well within legal expectations, state law, local law, and what we believe to be reasonable in expectations for students and the way in which our administrative team works. I also want to mention to you again, I've said this to you at earlier meetings, this summer we are going to be taking all of the administrative regulation documents that accompany these policies once they're all approved, and we're going to be updating our administrative regulations. That is an internal document for how administrators implement these policies on a day-to-day basis. And so we'll be updating that administrative regulation and set, and we'll be creating a manual for our administrators so that at the ready they have clear information about step-by-step what they're to do for these policies. For example, policy 227. Any questions at all on the 200s before we move forward? Okay, we have a little bit of time before June 7th, so if anything comes up, don't hesitate to ask. Otherwise, these policies are going to come forward on the 7th. Okay, and I'm going to dismiss Dr. Lutz because she is done with the 200s, and thank you very much for all your work in that area. Yeah, let her move on to some other requirements this morning.
Thank you.
Yes, thank you.
Thank you.
Thanks, Dr. Lutz. All right, so we're going to shift to the 300s. And in the 300s, you'll remember at our last meeting, we got through all the way through 325, dress and grooming. And so Ms. Kerr has been working to make sure that we're in alignment with state law and with our own district procedures, starting with 326, the complaint process. So Ms. Kerr, I'm going to turn it over to you.
Sure, thank you. Good morning, everyone. So actually, the rest of the policies that we have for today, there isn't a whole ton of changes. We did get through the 300s when we last reviewed, and they're pretty much still in compliance for the most part. So you won't see a huge amount of changes for these. The only thing that we added to the complaint process policy is that an accompaniment may be represented or accompanied by any district employee she chooses. It just said previously the policy said that they can be accompanied by anyone that they choose, and we don't allow outside attorneys to be present for any type of meetings. They can have their union representation, or if they're not unionized, we would allow a district employee. We don't allow just a random person off the street. So that's the one change that we made that we're recommending here, which I think serves us well. As far as 327, the recommendation is to delete the next policy. Mary Jo, can you move down to 327?
Sure. We actually deleted 327 at our last meeting.
Oh, we did that already? Okay.
Yeah, all the deletions we took care of
Perfect.
previously.
Okay, so then 328, compensation plan salary schedules. We didn't make any changes to this other than adding in the confidential and temporary employees to make sure that the policies related to all employees in the district. So that one stayed the same. 330 overtime. I just added in language here that said, as designated in the applicable administrative compensation plan, individual contract, or collective bargaining agreement, and how to compute overtime. Because the agreements, it is how you compute overtime is a negotiated topic, and it is discussed in our collective bargaining agreement. So I wanted to make sure that we were following that, if there isn't discussion in an agreement, then we're following the law, the FLSA law, and how we compute overtime. Job-related expenses. We changed the title from business manager to business administrator because that's what we call Kara. Reimbursements for expenses for outside travel is presented to each meeting. That's part of our bills report. And so that was a recommendation to add in here. And then saying that we'll develop administrative regulations for approval for job-related expenses, which is what we do anyway, but it's just stating that in here. There's also language in here. I think you probably remember we put the telework policy in place. So then there was language added into the job-related expenses policy in regards to teleworking and paying for any job-related expenses if someone is approved for remote working. Again, we added in here about travel and job-related expenses as defined by the collective bargaining agreement, compensation plan, or individual contract or board resolution. And then the use of a personal vehicle requires the liability insurance be, it said provided by the employee. We don't ask, for example, say there's reimbursement for someone to go on to a professional development, or is moving things around from maybe they're taking something to another district, or I know I had to go pick up COVID tests all the time. We don't require the employee to turn in their liability insurance, but we require the employee to have their own liability car insurance, which is if someone's using their own personal vehicle and get into an accident, it goes to the person's personal car insurance first. And then the district is the secondary insurance. So we just require the employee to hold that insurance, not necessarily turn it into the district ahead of time. So that's the one change that we made that wording.
So I'm just going to stop for a moment there, see if there's any questions in particular, because that section that's highlighted in yellow is a new section, again, related to telework. Are there any questions of the board?
No, thanks.
Okay.
Okay, so working periods, we added in the confidential and temporary employees again. And it basically just, this language adds in that the board has the authority to make modifications to the calendar as needed for health and safety. I think this is probably a COVID recommendation that we can make changes to the calendar if we need to.
And it also says that, and I appreciate that we've made sure that the compensation plans, contracts, collective bargaining agreements, we would always be in compliance with those.
Professional development, this policy, there really wasn't many changes. The only thing, the induction plan, there is a requirement to post our induction plan for inspection, but there is not a requirement to post it in the public library. I don't know why that was in there, but I don't know why we would, we post in the district. We don't post anything else from the district in our public library. So I'm not sure why that was in the policy, if that maybe that was an old law, but is no longer, it is not legally required for us to go and post our induction plan or our professional education plan in the nearest public library. So we took that out. We already posted on, it's available in the district, and we do any other postings as required.
The other section that's highlighted here, you'll see all in bold, is the added trauma-informed approach. And so we have made sure that we've provided training for our staff per expectations in the Pennsylvania Department of Education for us to make sure that our staff knows what trauma-informed approaches are. And so that's all added here. Also want to highlight that Dr. Johnston, who I excused from attending this morning, did review policy 333 in its entirety relative to our current professional development plan to assure that we're in compliance in each aspect. Everything from our year one induction all the way through the ongoing professional learning plan, we're absolutely in compliance with this policy, including the new trauma-informed education. Are there any questions on these few? All right, so we'll shift to sick leave.
Sick leave policy is pretty standard. We added in the confidential language. It's stating whether, if they're taking time off for sick, whether paid or unpaid, they have to submit documentation. And the language in here is just further describing the type of documentation from a licensed physician, but they added in certified registered nurse practitioner and licensed physician's assistant, since there are a lot more of those that are practicing, and it's a lot more typical to be able to receive notes from them instead of just an MD. Or the need to quarantine. We certainly have gotten lots of those notes at this time now.
Why would that be? I'm just kidding.
They added in language. We do have a professional staff sick leave bank, so they added in language here to reference the sick leave bank. We have administrative regulations that have been negotiated with the union and procedures in regards to implementing that. So basically, it just says that the board approves the use of a sick leave bank, even though you guys did approve the procedures back when we negotiated that with the union. FMLA, this is probably the one where we looked at and made the most changes, but essentially the recommendations from PSBA, I reverted back to our old policy because that's really what we had made those changes, that was actually really following our collective bargaining agreements. So all of our agreements have a fixed FMLA period from July 1st to June 30th, or the professional staff contract is September 1st to August 30th. So that's why the district shall utilize a fixed period from July 1st to June 30th unless otherwise specified in the compensation plan, collective bargaining agreement, or individual contract. It was really important for me. It is our standard practice, and it's really important for implementation of FMLA and all leaves in the district to run FMLA concurrently with any other leave entitlements the employee may have. That prevents the employee from stacking leaves, in which, say they went out on a childbearing leave, then coming back and stacking FMLA on top of that and staying out longer, and then stacking maybe some other type of leave, specifically going out for workers' comp on top of that. That just prolongs the time that the employee is out, and we run FMLA concurrently with all other types of leave that we have. And that's just their standard practice. So we need to make sure that that is stated in our policy to legally do that.
Because this is more substantive and with regard to change, are there any questions? Okay.
No.
All right, we'll shift to personal necessity.
Personal necessity leave is essentially personal days that are allotted to employees in regards to their compensation plan or their collective bargaining agreement. So that's why we added in and then it also talks about bereavement leave in here. Bereavement leave is defined in the school code, but there you can also negotiate who fits the different definitions for a near relative or an immediate family member. And we have made some changes in our collective bargaining agreement over the years that it slightly varies from school code. So that's why we added in the language as defined in the collective bargaining agreement for both of those items.
Okay.
Vacation is essentially vacation days that are allotted in the different agreements. And we added in the confidential staff members because they also receive vacation days, and talked about as defined in their agreement, contract, board resolution, or compensation plan. The language in here said that the board shall provide vacation days, and I changed that to approve. We don't want anyone to think that they're entitled to them, but we approve them. We actually pre-approve the usage of them. And then payment in lieu of vacation is permitted as defined by the compensation plan or the agreements, not upon necessarily board approval. We don't take the paid vacation days to the board. It's just defined in the agreement what they are entitled to, and then we implement that as the agreement states we should. So for example, if someone has vacation days left over when they leave the district, our agreements state that we pay them out at their per diem rate for any unused vacation when they leave. And the Act 93 agreement, administrators have a cap as to how many days unused that they can get paid out at their per diem rate at the end of each year. And that's an annual thing that we do. Sabbatical leave is really defined by school code. So this really comes pretty much directly from Pennsylvania school code. The one thing that is not completely clear in school code, and I wanted to clarify really with our policy so that it's written somewhere and we could refer to it. The one question I get is if for sabbatical, you have to have worked for 10 years within the state, 5 years consecutive in the district. And the one question I get is, does my time spent, say they started as an instructional aide and then moved up to a teacher, or say they started as a long-term substitute and then moved into a contracted position? My understanding is that the interpretation of the school code through different challenges is that it should be someone who's in an administrator or contracted position. Time spent as a support staff member was not relevant for sabbatical leave, and time spent as a long-term substitute when you're only here for, when there's no guarantee of employment, should not count towards sabbatical. So I wanted to make sure that that was clarified in policy. Compensated professional leave is essentially the other type of sabbatical you can take for educational purposes. The first policy, sabbatical leave, was really for medical reasons. So this compensated professional is the educational sabbatical, or typically referred to it as that. So we put the same language in about eligibility into this policy as well, because it's the same requirements. Uncompensated leave, we have always had this uncompensated leave policy in the district that say you need to leave for reasons that are different than FMLA, that don't meet that, or maybe you don't meet the definition of working enough hours to be eligible for FMLA. We could grant you a uncompensated leave if the reasons permitted under policy. So it might be medical condition of an immediate family member. Maybe you have to care for an immediate family member and stay home and do that. We saw that utilized during COVID a little bit more than typical. restoration of health. If you don't meet the definition of FMLA, we would put you under this uncompensated leave policy, and you could take a leave, basically a medical leave, under this uncompensated leave policy to restore your health. If there's some type of emergency circumstance or personal necessity as determined on a case-by-case basis by the superintendent. So that has been our policy in the district. The main change that we made on here was taking it from 10 days to 5, because that's really how we're implementing it for tracking purposes. If someone's out for more than 5 days in a row, we make them apply for an uncompensated leave or any other type of leave that's relevant. And then I took out child rearing / parental leave, because all of our agreements already provide a separate child rearing leave. So I felt like this was it was duplicative, and I didn't want someone to be able to take child rearing and then uncompensated on top of that. And this is responsibility for student welfare. This is pretty straightforward in basically saying that staff members are responsible for student welfare when they are in their care, and that each employee is responsible to ensure that students are supervised by a teacher or other staff member at all times while engaged in district activities. So this is pretty straightforward. Benefits for part-time employees. The only language added in here was saying that they're included in PSERS upon reaching either 500 hours or 80 days of employment in accordance with law. So this is just adding in the legal language for that. Jury duty, pretty straightforward. We added in the confidential employees, and then the way we handle reimbursement for jury duty, because the employee can't be paid by the district, which they are, and receive payment for jury duty, even though I know a lot of places, a lot of times it's only $9 a day. We have them get the check and either turn it over to us, or they cash it and then they write us a check for the amount that they receive from jury duty, and they're allowed to keep their pay from the district for the day, which is obviously much more than $9 for the entire day. Paid holidays, we just follow our agreements as far as that. There isn't much changes here. As you see, pretty straightforward. Workers' compensation, traditional return to work program. So we try to work with we didn't make any changes to this policy, but we do try to work with the employees to return them to work as soon as possible after a work injury. So this is the policy that we would follow in order to do that.
I'll just remind you, we already deleted 348 and 349 at a previous meeting. We put all our deletions on there. 348, you'll recall, was shifted over to 104.2, the anti-discrimination policy with regard to staff. So we already approved that earlier this year. And then the bullying, cyberbullying policy, PSBA doesn't develop any, they don't believe that that is something we should be including. Because it's already addressed in other policies. And then our last one, in the 300s.
Drug and substance abuse. We added in, obviously, to include confidential and temporary employees. And if you could scroll down a little bit, Mary Jo.
Sure.
We didn't make any other changes to this. We were debating on different things. And well, I think if you look at the cross-reference, believe they removed alcohol throughout the policy, the reference to alcohol, because the definition of drugs under the Controlled Substance Act does include alcohol in the list of drugs. So they didn't want it to separate it out, and it's just included. It didn't need its own wording in the policy.
All right, so this will conclude the 300 level. Are there any questions on any of the remaining policies that Ms. Kerr reviewed today? I know it's a lot at once, but most of the changes are minor, which is good. I mean, essentially these policies were in pretty good shape. The primary changes have to do with obviously changes in law. And again, a reminder, this cross-reference is a terrific summary document that you have access to that helps to show what PSBA has recommended and why in this third column. And then the fourth column, if they requested that we consult with a solicitor, we have done so in every case. All right. So there's only one other policy left. And let me just stop share for a minute because I want to make sure I share all of the correct information on this one. So this policy, and I'm going to go back in, it's called website development. And it was previously numbered as 816C, and it's now listed as 815.1. So we've been trying to stay in order with all the policies. And excuse me for 1 minute. Ms. Kara, thank you very much. I want to excuse you as well to be able to go on and get back to your work. And thank you very much for all the work you've done on these policies.
You're very welcome. Thank you.
Yes, thank you.
All right, so let me share my screen again. This is the last policy for today. So it was the numbers have changed. And so 816C has become 815.1 on website development. And the reason why we've asked to bring this forward at this time is specifically related to the student information safeguards. And this language here that says that we will not include personally identifiable information without appropriate parental consent. We would like to be able at the high school level to modify this language to allow for the first and last name of students. We have an opt-out policy, in our information on the website. For high school students only, we'd like to be able to modify this policy to allow first and last name, so that if students are winning awards, or if there's information about athletic performance in an event, that we are able to include the student's first and last name. The reason why this request is coming forward from the high school team is that our students, in particular our student athletes, are finding that when recruiters, athletic recruiters, who are interested in students participating in their collegiate programs, are looking for our students, they cannot find them with the same ease as other competing students, because other school districts allow for the last name of the student to be included in, for example, a playoff report, how many goals a goalie, how many goals the goalie saved, or how many shots on goal were performed by a particular student, or the statistics of a member of the football team, etc. And so there's a request that in order to better support our students' opportunities for post-secondary scholarships, that we allow for our current opt-out policy to suffice at the high school level only, so that first and last name can appear on the website. Parents could always opt out of that, but it would not be an opt-in, it would be an opt-out, where we would, the default would be to include first and last name beginning in the 9th grade, which is when, I wish it were a little later, but recruiters start to look at our athletes in particular as early as 9th grade in the way in which they're performing. So this is not referred to in the language here. I wanted to talk about it with you a little bit before we put language in place, but essentially we would include some language right there under student information safeguards to indicate that at the high school level, first and last name would be permitted on the website unless a parent opted out. So I'd be just curious for your feedback in that area.
Yeah, I think this is very appropriate, especially because students are going for those scholarships. It's very competitive. And so every opportunity we have for our spring field students to be recognized or to be able to be recruited or to receive scholarship, etc. This is really, really important. So if there's a parent, I like it better being, you can opt out if you want to, but there's always in there. So if there's a parent says, well, I don't want my child's name in there, then you can opt out. Otherwise, it's automatically opt-in. I think it's very appropriate.
I agree with Carla.
Oh, thank you. Thank you. And the previous policy, you can see on our website today, it has some very specific information about how that information gets out, we would just be clarifying that in this section. With the all of this entire section, we would modify to say that at the beginning in grade 9, parents would be informed that we would be using first and last names, and there would be an opportunity to opt out. So we would make sure that at the beginning of the year, we informed families of their choice, and then we would make sure that we did not include the last name of any student whose parents had opted out, much the way we do with photography. We have photography as an opt-out. And this is not only for athletes, this would be for any awards, et cetera. There are times where a student applies to a post-secondary program and then they are searched, they're Google searched by the organization, whether it's a scholarship organization or quite frankly, a place of employment. They're going to search the student, and not having the last name, our concern is that we're limiting our graduates' opportunities.
No, it makes sense. It's recruitment, and I don't know if this is good or bad, but it's happening even earlier than 9th grade. My 7th grader plays lacrosse for played lacrosse for the middle school. And he said there were college, I don't know how true this is, but there were college coaches who were looking at their practice. So it's happening. It's going to be elementary school soon.
Yeah, I hope you're wrong, but I do agree. And the board could decide that you want us to start with the 7th grade in order to include all interscholastic athletic competitors and all students who might be receiving awards like, Young Playwrights Awards, et cetera, as early as the 7th grade. We could do that. I have some concerns about under the age of 14 or below high school, but you are correct that I can tell you for sure that in certain sports, recruitment begins in the 7th grade.
I agree with you. I think it makes sense to wait until high school for many reasons, several reasons, not just the maturity piece of it, but
Yeah.
and having to do with other board policies. But yeah, I think we should start at high school.
Okay, I appreciate that. I mean, with the new name, image, and likeness policies around the NCAA, we're going to have high school students, if they're successful, who are going to begin to be offered beyond scholarship money, endorsement money, when they're still high schoolers. And so it's troubling to me, but nonetheless, that's where we are. Okay, so we'll add that language under student information safeguards. And that is the last policy that we have for you at this point. And as I mentioned earlier, so we would be picking up with the 600 level later in June. And the hope is that we can do all of the 600s at one time. If I quickly show you, if I go up, just move this, apologize, I'm just shifting some things around. That is the entirety of the 600s. It's a very short list of policies. So I do believe that we'll be able to get through them quickly in June. And that'll just leave us 700, 800, and 900 level policies. We've done a few 800 level policies this spring, but it'll leave a very manageable amount for us for the fall semester. Okay. Are there any other questions or anything else regarding policy that the board would like us to be taking a look at before the end of the school year? Okay. All right, well, thank you very much. And it doesn't look like we have anybody who joined us this morning, so we don't have any public comment. And so as long as you guys are okay, I'm gonna say that we'll adjourn the meeting.
Sounds great. Thanks a lot. Good morning.
Thank you all.
Everybody have a good weekend.
Have a great day. Thank you very much.